Good morning, friends. Today I am going to discuss the concept of jurisprudence. Jurisprudence means the prudence of law or philosophy of law. And what does it mean? What is philosophy? Philosophy means the question of why. The question of why is the most important and fundamental question. As far as we know, the question of how is concerned, which is applicable in the field of science. The science deals with the question of how, the method. What about philosophy? Philosophy starts with the question of why life, why we are, what is our identity, why we are here. These are the most significant metaphysical questions which is speculated by the human's mind. If you look at the ancient jurisprudence started with Vedas, Upanishads, particularly Upanishads, you can find out that how people started speculated about life and death. A similar kind of speculation could be found in the philosophy of Plato, Aristotle, Kant, etc. So it means that the question of why is very significant in our life. And whenever we live our life, we don't question why we are living our life, what is the meaning of our life. So these are the questions which is often asked by philosophers, and every human being is a philosopher in a sense that every human being is in search of meaning. Without the search of meaning or without the meaning itself, a life is not possible. So in that sense, the question of philosophy is not simply related to metaphysicians or the scientists, but it is about the human days, human behaviors, which is ordinary behaviors of every human's life. Now, I would like to connect this theme of philosophy with the philosophy of law. The philosophy of law started with this question: what is law? Why law? What are the characteristics of law? How can we identify law? How can we understand the development of law? And what is the function of law? These are most important questions in jurisprudence. The first question is, what is law? And what is law itself is a very controversial question. And to answer this question, there are so many schools of law which try to define the meaning of term law or try to speculate about the various contours of law. Started with natural law tradition in the Western jurisprudence, or the tradition of dharma in Eastern jurisprudence, or the tradition of Taoism or Confucianism in China. All these schools of philosophy tried to understand the meaning of law in ordinary life or in the life of universe. So, in natural law tradition started with, in Greece, philosophy of Socrates, Plato, Aristotle, and then Roman period we have Seneca, Marcus Aurelius, Cicero. And then we can find out in medieval period our scholastic traditions started with St. Augustine, and then in 12th, 13th century St. Thomas Aquinas. These philosophers speculated about the meaning of law in their own way. And ultimately, when the secularization started in Europe after the Protestant movement, and the philosophy of Calvin and Luther made a huge impact in the philosophy of secular jurisprudence in the Western categories. And thereafter, you can find out that Immanuel Kant was the great father figure of Enlightenment, and Voltaire, Rousseau, Diderot, etc. They played huge role in the development of the secular foundation of law in Western jurisprudence. So, those philosophers speculated about the question of law, or at least provided the legitimacy of law, that why law is necessary and what is the meaning of law. But when you look at the modern period, started with logical positivism in the philosophy or legal positivism in law, you will find out a different kind of tendency emerged, particularly with the philosophy of Descartes and Newton. The people started to speculate the mathematical foundation of universe. Especially Descartes was very much curious to know the nature or the language of nature. And Descartes speculated that everything in nature has some shape, some motion, some structure, and that could be speculated through numbers. Likewise, Newton found this universe a mechanical universe which could be understood by the human being, by the rational mind. So they did not give emphasis upon the moral questions or the questions related to emotions. They were interested to understand the mechanical structure of the universe, mechanical structure of nature. So same kind of impact could be seen in the social sciences when Auguste Comte, Herbert Spencer, Emile Durkheim, people like these started to develop the philosophy in social sciences, especially sociology. Similar approach could be found in psychology, started with Sigmund Freud, Carl Jung, etc. So, similar kind of approach could be seen in the philosophy of jurisprudence, whereas the logical positivist and thereafter legal positivist started to discard the metaphysical foundation of law in natural law tradition. Particularly, one of the great philosophers of legal positivism was Jeremy Bentham, and he found that the natural law tradition made the law very vague and abstract. And it is required to establish the firm foundation of law, and that is possible only if the jurist or the people who are interested to understand law try to investigate what is the meaning of law or what is law instead of what ought to law or various kind of speculation in the name of nature. Because what is natural is a very difficult question to understand, and nobody can say that this is the sure and certain meaning of nature or natural. So in the name of nature, naturalization is very natural. And that's why Bentham discarded the idea of natural law tradition by saying that these are nonsense, and he established the foundation of modern legal jurisprudence, that is legal positivism. What is legal positivism or analytical positivism? Positivism means as it is, something which exists. So whatever is existing in current time is the reality, is the present moment. So that is a very significant question for the purpose of understanding modern jurisprudence. And thereafter you find legal positivism or analytical positivism. Means you can understand what is law through analysis, through logical analysis. You can understand, you can recognize what is law, not what ought to law. Law kya hona chahiye is not important. What is law is most important question. So that's why you can see the influence of Bentham could be seen in later jurists like John Austin and H.L.A. Hart, Professor Joseph Raj, etc. So these people established the foundation of legal positivism. Particularly John Austin put emphasis upon command, duty and sovereign. What does it mean? The focus of this particular school was legitimacy of law, not efficacy of law, not utility of law, but mostly legitimacy of law or the recognition of law, how to recognize the law, how to understand that this is the law. That was the main focus. So Austin was influenced with Roman law tradition, and in Roman law tradition you must be aware about Justinian codes and 12 table codes. So these are the famous codes which were prevalent in Roman jurisprudence. Roman jurisprudence was very much systematic jurisprudence which made huge impact upon the mind of John Austin. So John Austin was influenced from the Roman jurisprudence. He was also a part of military in earlier life. So he liked the discipline, and that's why he was deeply influenced from the philosophy of Machiavelli and Jean Bodin. And these people established the foundation of sovereignty or the unlimited indivisible sovereignty. So these philosophers influenced the philosophy of John Austin, and that's why John Austin gave the emphasis upon sovereignty, that is unlimited power, that is indivisible power, that is in continuous process. And he also put emphasis upon the law and meaning of law, and that was categorized law improperly so called, law properly so called, And for him, law improperly so called is a no meaning of law. It's just like law of metaphor, law of nature, etc. But whenever once asked the question law properly so called, it deals with those questions related law given by human being to another human being. Again, in law properly so called, it is also a kind of two categories. The one in which one human being is giving law to another human being, in which the relationship is not like political superior and political inferior. Both human beings are at equal footing. So such kind of law is merely a positive morality, and one can understand international law for the scheme of John Austin. It's no law. However, John Austin defined another category of law, that is law properly so called given by political superior human being to political inferior human being. And the political superior human being is considered as sovereign, and political inferiors are those subjects or citizens who are in the habit of habitual obedience of law. And that could be ascertained that these peoples are habitually following the law. That command given by the sovereign must not be the particular command, but it must be a general command which is issued by the sovereign, and that is habitually obeyed by a certain group known as political inferior group. Either you may call them subjects or the citizen. So only that aspect of command is considered as law as per the scheme of John Austin. Okay. So John Austin said that there is a command given by sovereign and it is followed by people who are politically inferior. They are under obligation to accept the law and follow the law, and if there is any kind of violation of law, then punishment is the natural consequence. Okay. So this particular aspect of jurisprudence or the philosophy of law of John Austin was developed when there was primitive modernity. The modernity was in that not in advanced stage, but it was still developing. Later on, it was criticized, particularly if you can remember that after Nazi regime in Germany, Nuremberg trial was constituted, and the question was asked, what is the meaning of law? Whether the people like Hitler who were giving command could be considered as law or not. And the legitimacy of law like this, simply because there is a command of sovereign, could be said as law or not. So this particular nuance of law was questioned by the jurists at that point of time, and said laws should have minimum content of morality. So whatever Austin was saying, which may be an attempt to discard the tradition of natural law, but ultimately the Nuremberg trial or the Japan trial, Tokyo trial, established again the firm foundation that law should not be simply the command of sovereign backed by sanction. Rather, law must have some minimum content of morality. And that's why this question of natural law tradition again re-emerged after Second World War. So what we find that the philosophy of H.L.A. Hart developed in advanced modernity when modernity was at peak. And H.L.A. Hart tried to remove the anomalies of Austinian philosophy and establish the foundation that law is simply two kinds of rules, primary rules and secondary rules. The primary rules are found in the society, in the evolution of society, in customary practices, in the conventions, in the behavior of people, in social transactions of the people, general expectation of the people. So these are known as the primary rules. The primary rules are not law in itself unless and until there are secondary rules, and which may provide the legitimacy and validity of law. So secondary rules consisting of rule of recognition, rule of legislation, and rule of adjudications. So these are certain secondary rules which are necessary to provide validity or the legitimacy of the primary rules. And without that, one cannot say that the primary rules are the law. Okay, so Hart tried to remove the anomalies of Austinian philosophy and felt that Austin spoke in a very language that is not suitable, because there are so many laws in our life which may not be backed by sanctions, which may be followed by the discipline of the people, inculcating the discipline that one has to follow certain rules without being feared, without being ordered by someone, without having any fear regarding the sanction. So in that sense, there is respect for the law for the people. That's why people respect the law. It is not only a fear factor that is important behind the law. And that's why Hart tried to establish a different kind of philosophy. Even Hart conceded the idea that there should be minimum morality, minimum content of morality in law, without which it is not possible to have the law. Okay, so these are two important philosophers of analytical positivism school. And thereafter you can find out Hans Kelsen. And Hans Kelsen, German philosopher, was very much influenced from Immanuel Kant. And Hans Kelsen understood the philosophy of Austin, that is something whereas the complete establishment of law as a separate discipline, without being influenced from sociology, philosophy, etc., could not be established by earlier philosophers. So Kelsen was interested to establish a pure theory of law in which law is uncontaminated, it is a pure in nature, without being influenced from any other disciplines like philosophy or sociology or psychology, like that. Because according to Kelsen, when Austin talks about command of sovereign backed by sanction, it means that people are following the law not because of the respect of the law, rather they are following because there is a fear factor behind it. And whenever there is a fear factor, there is a psychic experience of fear in the mind of people. So there cannot be a separate discipline of law if there is a psychological element involved in the obedience of the command of the sovereign. Isn't it? So Kelsen was interested to establish the purest foundation of law, and that's why he talked in the different kind of language. He said law is a normative science, and the one norms gets the validity from the higher norms, and the most highest norms is the ground norms. Now you must be aware that there must be some place where you have to stop, isn't it? You cannot go on. There is some higher authority, then higher authority. Then once you can find out that this can go in infinite way, it may follow the infinite regression. So you need to stop somewhere, and that's why Kelsen said that there is a grand norm, that is the highest norm, and beyond that there is no norm. Just like if you start questioning about life, why life is possible and who has created the human being, you have to stop somewhere. It may be the idea of God or idea of nature or idea of universe. You must stop somewhere, because beyond that you cannot go, isn't it? So likewise the idea of grand norm is there must be some area of full stop, like a Constitution of India. Beyond that you cannot go. The Constitution of India is the highest authority or highest law of this land. Now this is the grand norm. Beyond that you cannot go. That grand norm will provide the validity of all sorts of law, started with legislation, codification, customary behaviors, conventions. These all are the sources of law that gets the validity. These are the norms in the language of Kelsen, and that gets the validity from higher norms. And the most highest norm is known as grand norms. According to Kelsen, this norm is de-psycholized norms. There is no psychic element of fear or love or passion or desire behind the law. Law is neutral. Law is empty. Law is formal. It is a formal category. And whatever you give the content in it, it is your choice. It is the choice of the sovereign. It is the choice of the state. You provide whatever content in it. But ultimately the structure of law is like this. That there is an empty norm, empty category, and one category of norm is getting validity from the higher category of norm. So two important facets are implicit in his philosophy. The first point is that he is establishing the idea of formal rationality, what Weber once said. there is difference between formal rationality and substantial rationality. Formal rationality talks about form, the idea of form, and you can look at the philosophy of Plato, Aristotle. Greek philosophers started this question of form and substance. What is the meaning of form? What is the meaning of substance? So form is very important. So law has a certain form and law has certain substance. Like even if we are doing something in substance, but it is not law unless and until there is some formal recognition of it, isn't it? So in society, so many things are happening. But all those things, all those social behaviors could not be considered as law unless and until there is some mechanism by which it is recognized as law or it is respected as a law. So in that sense, the formal category means there is a form of law. You can recognize this is law because it has a form of law. And there is a substance in it, isn't it? So that substance may belong to the history, society, custom, conventions. It may come from the mutual understanding, agreement, whatever way you can put any substance in it. But ultimately, it has some form. So, Kelsen was talking about that formal rationality in which a law is simply a form, empty category. And you have to provide the content in it. The society has to provide content in it through mutual agreement, through general agreement, through social contract, in whatever way, isn't it? So it is a normative science. It is not a psychologized norm. It is de-psychologized norm. There is no psychological element in it, and it is ultimately a formal category, empty category. And whatever content you will provide it, it is up to you. But ultimately, how will you recognize it is law? Because it has certain formal aspect, and if it is available there, then you can say it is law. Okay? Because he was influenced from Kant, and Kant developed the idea of categorical imperative. What is categorical imperative according to Kant? According to Kant, when human beings are autonomous human beings, they are not being influenced from outer considerations like hunger, desire, fear, etc. When human being is not developing the idea of morality from the perspective of these external aspects of life, because we are all the social animals, we are influenced from fear, hunger, desire, we are all at that level are animals. But when we go beyond that, we can find out some human dignity involved in us. We are autonomous in comparison to other animals. So when we are autonomous and we work as autonomous human being, we can develop certain moral categories, moral philosophies, which is beyond the animal kingdom. And that is possible only if we are not affected by external factors. So, taking the clue from this particular philosophy, Kelsen developed this idea that law must not be influenced from the sociology, philosophy, or external things. Law has internal dynamism. It has own internal process, and it is a formal category. So, ultimately, you don't have to discuss about substantive rationality. It is up to the society itself or the human beings which are involved or who are involved in that society. They have to decide what kind of content they are going to give in the nature of law. But ultimately, you can recognize the law because there is certain formal categories, formal recognition you can find out in it. Okay, so this is what Kelsen philosophy of normative science of jurisprudence is. This is the one school. These are the three philosophers, and you can understand this philosopher in this sense. Then there is another question regarding the law. It is not simply recognizing what is law or what is the legitimacy of law. There is also a question of utility of law or the function of law. Because there is one thing to say there is a law or we can recognize it as a law. There is another thing to say whether law is functioning or not, whether law is respected by the people or not. And when we say that without respect of law, law is meaningless. You made the certain laws related to many social evils in our society. But those laws are not followed by the people in their general behaviors. So still it is law in the nature of command of sovereign. It may be law recognized by official gazettes of the government. But ultimately what happens that it is not followed in the society. It has no efficacy. It has no utility. So that's why the question is asked that simply because we recognize something as law, does it mean it is law? Or we must have some understanding what is the utility of law or the function of law. Okay, and this particular question is raised by sociological jurisprudence or sociological school of jurisprudence, led by Roscoe Pound. So Roscoe Pound gave emphasis upon the functionality of law. Okay, so he said that the role of law is to solve various interests, various conflicting interests in the society. There are certain social interests, there are certain public interests, and there are certain individual interests. And there is a conflict, constant conflict going on in the society. Between so many conflicts, you have to harmonize those conflicts so as to provide maximum satisfaction with the minimum friction in the society. It is a kind of utilitarian philosophy, and utilitarian philosophy influenced by Bentham, John Stuart Mill, etc. So Roscoe Pound is saying simply you have to establish harmony in the society through the law. And law, the function of law is to establish the harmony, to minimize the conflict, to establish the peace, to establish the harmony between various conflicting interests, and that's why it is a process of social engineering. And the lawyers are the social engineers, and they are supposed to harmonize between the various conflicting interests. Okay, he was influenced from certain philosophers like Ehrlich. These are the philosophers which deeply influenced the understanding of sociological school of jurisprudence. Roscoe Pound was influenced from Ehrlich, particularly the interest theory. He was also influenced from Ehrlich and living law theories. He was influenced from other philosophers like idea of jural postulate, because according to Roscoe Pound, every society has certain jural postulate, basic understanding, basic standard of jural or law. So that society expect that certain jural postulates must be followed. So whenever law is made, the law must be made keeping in mind those jural postulates. And as per those jural postulate, because this idea of jural postulate came from Kohler, and this particular idea influenced Roscoe Pound. So Roscoe Pound said, whenever you develop the law, you have to make the law under those jural postulate. Isn't it? Every society has certain basic understanding of law, basic understanding or basic general expectation from its people. So if you follow those jural postulate, that is very important to establish the foundation of law. And you have to harmonize various interests while keeping in mind those jural postulates. You cannot go beyond that. Just like you have to protect the interest of elders, you have to take care, you have to provide pension for the people in old age, you have to take care of children in the society. These are the basic jural postulate available in the society. So whenever you are harmonizing the interest, you have to keep in mind that these jural postulates must not be violated. It must be protected, it must be respected. Isn't it? So that is the idea of Roscoe Pound and social engineering theory. Okay, and there are certain other philosophers in this school as well, but their whole emphasis is not to know what is law or how to define law or what is the meaning of law or what is the linguistic aspect of law. Their concern is to know the functionality of law, what the law does instead of what law is. So there is a paradigm shift, understanding or the questioning the law. Another school is a historical school of jurisprudence, which deals with development of law, how law evolved. Because history means time. Time means law is not made in one day. It has an evolutionary process. Like in Darwin, changed the paradigm of understanding life, nature. Likewise, Savigny changed the paradigm of thinking about law in historical perspective. He was influenced from Montesquieu, he was influenced from other philosophers, but he was considered as the Darwinian before Darwin because he thought that evolution is the fundamental basis of law in the development of law. How law evolves is the most important question. So Savigny was a jurist in Germany, and Germany and France was always at war, or at least there was some kind of tension between one nation and another nation because of extreme nationalism in Europe. So German people were very much nationalist people, they were romantic people, they were considering that their nation is the supreme nation. And you must be aware about romantic movement in Europe after Enlightenment, led by Rousseau and Fichte, Schelling, etc. So the romantic movement made huge impact upon Savigny thought that Germany is far more superior nation than other nations. So when France, in the leadership of Napoleon Bonaparte, started to codify the law, the similar kind of argument was raised by Professor Thibaut in Germany. And Savigny opposed the idea of codification. He was not absolutely in a position of codification, but he was thinking that law is still in nascent stage in our society. It must not be codified yet. If it is codified right now, then it will lynch, it will stifle the very possibility of growth of law. According to Savigny, law is still evolving. It is not mature. It is not adult. It is still minor. So it must evolve. And if we are going to arrest it through codification, then its development will not go further. And that's why Savigny developed the idea that law is found in the spirit of people. It is Volksgeist or Volksgeist. Geist is very important term in Germany. So German language. So Volksgeist means spirit of people. Law is found in the spirit of people. Law is related to nation. Its birth is connected with the birth of nation. It grows with the growth of nation, and it dies when the nation loses its nationality. This is the fundamental postulate of Savigny. Savigny says that lawyers are the mouthpiece of law, and they are supposed to discover the law. Customary laws. Law is not made like a legislation. Law is found in the society. It is found in the customs, in the behavior of the people. It is in the spirit of the people. It is a Volksgeist, and it is connected with the nation. So we cannot imitate France. We cannot imitate other nations. We have a different nations, different culture. We have different, nation means nation has organic structure. It has different structure. It is different from other nations. So whatever we have as a law, we should not imitate other people, other nation, and we must respect the customary practices of this country instead of codifying it, stifling it, protecting to grow further. Savigny opposed the idea that law should follow any kind of process of legislation. Okay, the similar kind of or approach could be found in the anthropological studies by the Henry Maine. Particularly, Ancient Law is a very significant book written by Henry Maine. So Henry Maine made comparison between various legal systems throughout the world, particularly Indian legal systems, common law system, etc., and Roman legal system. And Henry Maine came to the conclusion that there are two types of societies: progressive society and static society. The certain societies are a static society in which law develops from certain stage to certain stage. It develops from the stage where law is in the nature of command of divine sanction of the king, and thereafter it becomes customary practices, and thereafter it is captured by the group, priestly class group, and certain revolt takes place by the general masses, and codification takes place. These are the four stages in which law develops in those static societies. But when we go beyond the static society, in progressive society, law even develops further from these four stages, and it starts developing with the technique of fiction, equity, and legislation. These are three different methods to develop law in progressive society. What is fiction? Fiction is a method by which the form of law is not changed, rather the spirit of law is changed. So the structure of law remains the same, but the interpretation of law changes. People generally are not aware whether the law has changed or not, but ultimately it is because of certain techniques of interpretation the very significance of law is changed. So it is a method of fiction. And thereafter, equity. Equity is again a method developed by Chancery Court in England, and in Roman jurisprudence, Praetor's edict was passed. So that was also a source of equitable jurisprudence. So equity means if you don't have any law, you don't have any source of legislation, and you have to decide a case, you have to do justice with the people. So how will you do it? So you will follow certain principles through which you have to decide a case and to do justice with all the parties. So equity is that method by which you can do justice with the people, even if you don't have source of any legislation or any law prevalent in that point of time. Prevalent at that point of time. So the question is, that is the second method. The third method is legislation. Legislation is a science of making law, which is a modern science of law. Legislation and codification both are different things. Codification means simply codifying the existing law, but legislation means making a new law. It is futuristic. It is prescriptive. It talks about something which does not exist at that point of time, and through legislation you can create new law. Like criminal procedure code is all about codifying the existing law. But when you talk about a specific relief act, it is not simply a codification of existing law, but rather it is creating a new law, isn't it? So according to Henry Maine, Indian society for him was not a progressive society, and for him Roman society or British society was progressive society, because those society developed certain techniques to go beyond codification and to develop new science of law. Okay, so that is the historical method used by Sir Henry Maine, and it said that law developed from a status to contract. Law hitherto developed from status to contract. What is the meaning of status? Status means that you don't have a right to decide for yourself. It is your families, it is your nation, it is your caste, it is some kind of group who is deciding the fate of yours. So it is a status, it is a predeterminism. And when you talk about contract, the spirit of contract is there is a freedom of will. Freedom of will means there is autonomous choice by the people himself, can decide about herself or himself, who he is or she is, what is her identity, etc. So in that sense, that is the spirit of contract. So according to Henry Maine, if you look at the historical foundation of law, starting with Greek to postmodernism or modernism, at least in Henry Maine's time, you can say that law has hitherto developed from a status to contract, but predeterminism to determinism, predeterminism to free will, isn't it? So that is the whole idea of Henry Maine. Though there are so many criticisms, because in our society you can find out so many ways of status. In our society still who will marry to whom, family decides. What will be the wages for the laborers, trade union decides. There are so many ways you can find out where which still a status exists. Even if we can say our society is a progressive society, but it is not a complete contract everywhere. Status exists, predeterminism still exists. So even in society of English society, Roman society, Western society, the idea of a status still exists. It is not like that complete idea of contract is prevalent. Okay, so there are so many criticism from the perspective of anthropological study of law. However, Henry Maine did a great job looking at the law from historical point of view and the comparative point of view from various legal systems to understand what law is or how law evolved over the years, starting with ancient societies. Okay, so these are three different schools you have to understand for the purpose of examination. Other schools are also there, which I may discuss in later lectures. And you have a very good syllabus, particularly Delhi University syllabus. You can find out that the first topic is major legal system of the world. So there are certain good readings. N.R. Madhava Menon, Our Legal System. This is very good writing. So you can read it, and you must understand that what are the basic systems, legal systems in the world, like canon legal system in medieval period, or German or Western legal system. There are so many continental legal systems, common law legal system, Indian legal system, so many legal systems and so many basic characteristics of these legal systems. You have to understand. You have to be a student of history to understand what are the major legal system in the world, and particularly what is the nature of Indian legal system, what is the legal system itself, and then thereafter Indian legal system. It is about the system related to law. So system related to law does not mean simply the development of law or legislation or codification. It means court system, adjudicatory processes, legal professions like lawyers, police structure, prosecution. All these are how evidences are taken, what is the role of forensic science. All makes the whole complex web of system, isn't it? So Indian legal system consisting of all these things, and we have to understand the nature of each of it. So every part or every aspect of legal system is a complete or you may say ocean in itself. It is huge in nature, and you have to understand even police structure itself is a very complex question. Police reform is a very complex question. Prison reform is a very complex question. And thereafter you will find out whole structure of rights, legal rights, constitutional rights, fundamental rights, natural rights, human rights. All these are related with the idea of a system that is a legal system. So not only normative aspect of law, but also institutional aspects of law, procedural aspects of law, all these are involved in a legal system, isn't it? So we have to understand the nature of legal system from that perspective. And thereafter we have another topic, a structure of Indian legal system, basic principles of law and rule of law. So our legal system follows rule of law, Dicey's rule of law, or rule of law, not rule of man. It is not about powerful will rule the weaker. It is about the law is supreme and every person is equal before the law, and equal protection of law will be guaranteed as per Article 14. So Dicey's rule of law, legal spirit must be dominant, equality of law, all people are equal before the law. These are the aspects of rule of law. We are aware about that. So that is the one aspect. Then separation of power started with Locke and then Montesquieu, and that is followed in our Indian Constitution. We can look at Article 50, I think, separation of executive and judiciary. So there is separation of power existing in our Indian Constitution, in our structure of three wings of the state: executive, legislature and judiciary. So separation of power is followed, not in classical strict sense, but it has its own different mechanism developed looking at the various legal system in the world. Our legal system is unique legal system. It has unique structure of separation of power. Then we have legal services and Lok Adalat. These are a different kind of modification, or you may say some reformation took place in order to ensure access to justice, because the legal system is meant to provide access to justice for the poor people. So that's why legal services and Lok Adalat is very significant in nature. Then hierarchy of courts, it is followed from British people. There was no hierarchy as such in India before the British people came, or even if it was hierarchy, but not in a sense what they developed, very systematic kind of hierarchy in the system and jurisdiction, isn't it? And then method of legal studies, how legal study is taking place, how you can understand law, how can you make legal study. These are the aspects in second chapter. So you have to look at the reading. You must read reading, and you must reflect. You must think about that. There are so many sources of law: custom, legislation, precedent. Customary law prevalent in India. Legislation was a different kind of science evolved from common law system. And precedent again is a very significant source of law in the development of common law system itself. To follow, to obey the higher courts, or to follow it like it is a law of the land. Article 141 of Indian Constitution, the principle of stare decisis. So that is the idea of precedent, isn't it? And but that must be taken as law of the land, isn't it? Even if judiciary is not meant to make the law, legislate the law, but even if judiciary is simply meant to adjudicate the conflict or to interpret the law, but that interpretation sometimes becomes very significant, because precedent has to be followed throughout the country as per the demand of Indian Constitution, isn't it? Then legal profession in India. You must be a historian. You must read what is legal profession, from where it started. It started in Roman jurisprudence, whether it was prevalent in Greece or not, whether it was prevalent in Vedic society, post-Vedic society in India or not. What was the status of legal profession in medieval period in India, in Mughal period in India, in the period of Delhi Sultanate, and thereafter in modern period, from where this legal profession started, especially when the reception of common law took place in India. Thereafter, the legal profession in current form developed. So you can understand these things. You don't have to read these all things right now for the purpose of examination. For basic understanding, you may read these things, isn't it? So Advocates Act 1961 is very important, and A.N. Veera Raghavan's writing is there. And Glanville Williams is a fundamental, very brilliant writer. So you must read his book, Learning the Law. That is the most basic book for every law student. I already discussed these schools, and the last point is right and duty. Right and duty, you have to understand Hohfeld analysis of right and duty. You can read any basic readings to understand the nature of right and the nature of duty. Particularly started with the idea of right in French Revolution, or the Declaration of Independence in America, or the Glorious Revolution in England. Then thereafter the very basic documents of Universal Declaration of Human Rights and those covenants, and of course fundamental rights in India. So there is a great history of rights. If you look at the literature of Rights of Men written by Thomas Paine, and Rights of Women also was written by Mary Wollstonecraft. So these are some of the basic writings related to law, related to right, and a similar kind of expression could be found in the writings of those jurists belonging to America. Yeah, isn't it? So Thomas Jefferson, Madison, etc. So there is a huge history of right, or you may say big history or long history of rights is the correct word. Long history of rights. And in India, from where the concept of right emerged. We have rights in our Indian constitution. From where it emerged, from where it evolved, we have to inquire about that. But for your understanding, first of all, you have to understand what is the nature of right, how right is related to duty. Is it possible to have right without duty? Or is it possible to have duty without right? Whether right and duties are complementary to each other. Whether right and duties are necessary for human society. These are the fundamental questions you have to ponder upon. Okay, so that's all for today's lecture. In future, I will discuss these topics in details. But for today's, this is all what I can explain. Have a nice day.